Hello. Today's topic is the return of the Social Security no match letter, what it means and how to protect your business. Our speaker today is Peter Guattery, attorney at Whiteford, Taylor and Preston. Thank you, Peter.
Thank you. Hello, everybody, and thank you for listening in on this webinar. Wanted to give a little presentation to everybody about the Social Security no match letter, which seems to have returned. Some of you may have received them. Some of you may live in fear of them and may have heard about them coming down to other employers that you know. And it was an opportune time to discuss what exactly they are, what do they mean, and how best to address them. So with that in mind, let's look a little bit about the history. These Social Security no match letters first started in 1993 and continued up until about 2012. They were utilized by the Social Security Administration to notify an employer of discrepancy between the Social Security records and the employer's own records, and typically were produced as a result of some mismatch on the tax filing reports from the employer and the name of the individual that's assigned to the Social Security number. At the very beginning, they were originally being issued for employers with high numbers of mismatches, but then they became more broadly available. As a result, this created some degree of controversy, raising concerns about audit and constructive knowledge of the Immigration Reform and Control Act, which most of you know is the I-9 process, the process by which you verify the employment authorization of a particular individual for employment. And what concerns were raised was that a particular employee who was listed on the no match letter would in fact be somebody who was unauthorized, and that as a result this might lead to investigations, audits, fines and penalties, and perhaps even prosecutions should there be a substantial number of no matches. So you can understand what type of concern there was. In order to address this concern, there were final regulations issued by the government in 2007, which provided a roadmap for resolving discrepancies between Social Security numbers and the individual employee names, so as to avoid finding of constructive knowledge. Those regulations were blocked by court order, never went into effect, although they are still available if you look for them, and they do provide a fair degree of guidance as to what a reasonable approach might be in addressing a discrepancy in order to avoid a finding of unauthorized employment and constructive knowledge on the part of the employer. So shortly after that, in 2012, the Social Security Administration stopped issuing no match letters. Well, in March of this year, the Social Security Administration announced a resumption of the program, meaning that Social Security mismatch letters are now being issued and employers are receiving them and expressing concerns about what exactly they're supposed to do. The first and most important rule for Social Security mismatch letter is do not assume under any circumstances that the receipt of a notice, which includes the employee's name, and I believe in these currently they're giving you a link to the Social Security database to identify the names rather than having them listed, that these individuals on the list are unauthorized. There are many, many reasons. And when I say unauthorized, I mean not authorized to accept employment in the United States. There are many legitimate reasons for why there may be a mismatch. The most common one might be a change of name. The individual might have gotten married and changed their legal name, or they might have gotten divorced and then changed their legal name again. There may be a transcription error. This could come from the employee writing the numbers down incorrectly, or perhaps in some cases deliberately incorrectly in order to avoid paying taxes. Or it could be that the numbers were transposed when they were put into the employer's database or transmitted to Social Security. So there could be any combination of reasons as to why the numbers may not match. There may even be double surnames. Culturally, there are some cultures where they use both the maternal and paternal surnames. And those that usage sometimes results in the first surname being used on one document and the second surname being used on a second. So there may be different surnames at issue, and it might still be the same person. And sometimes it's worthwhile to look at those records to see what exactly whether that's exactly the reason for the discrepancy. So what are you going to have to do when you look at these? Well, you're going to have to assume some type of plan of action in order how to address the problem solution that is methodical and consistent. And so what does that exactly mean? Well, first and foremost, you should check your own records for possible errors and discrepancies in the documentation. This means looking at your W-4, the W-2 that's issued, looking at the employee's documentation provided in connection with the I-9 process. They may have provided a document there which has a different name than on the Social Security card, and that may be because of a change in name, and that might be the problem. So you might be able to resolve the issue in that way. If you're not able to do so, you should then notify the employee of the mismatch and identify to the employee the steps you've taken to try and confirm it and that you've not been able to do it, and advise the employee to do the following. Check their own records, confirm that they provided the correct information, confirm that they don't have any other documentation that might resolve the discrepancy, and direct them to Social Security Administration if they need to take steps to correct the error in some way, such as updating their name or providing updated information that might resolve the discrepancy. And you're to provide the employee with a reasonable period of time in which to address the problem. Now, the current notices are giving up to 60 days to report to the Social Security Administration of the steps taken to address the discrepancy. And it may be that some employees don't have information to report after that 60 days, in which case that may be reported to the Social Security Administration that the notice has been given and the employees in an effort is taking steps to resolve the discrepancy. It may be that if that's the case, that still doesn't necessarily mean that the employee is unauthorized. And then the question is, how do we address it? The situation with employees who have not been able to verify their Social Security number within the 60 days, and they're still in the process of taking steps to document their employment authorization for you. That's where the old DOJ regulations come into use, and that is that they provided a 90-day window for resolution of discrepancy and a step-by-step process in which you would connect with the employee to try and address why there may be an issue between the Social Security number that they provided and whether or not that contradicts their employment authorization status. Obviously, if an employee gives you a valid employment authorization document as part of the I-9 process, and otherwise their I-9 is complete and the only issue is the Social Security number, then they're not necessarily unauthorized. It may be that they have been using somebody else's Social Security number. They may have been using a number that isn't a valid number in any circumstance. Or they may have, like I said earlier, transposed numbers. In either of the first two situations, those individuals may not necessarily be individuals you wish to retain. They may be subject to employers' policies regarding dishonesty in applications, but that's an employer approach to take. But I would admonish employers to remember the rules for I-9 documentation in the context of it receiving any Social Security mismatch letter, and bear in mind that there are issues relating to document abuse under the I-9 process and non-discrimination provisions which may apply under state law and federal law, including federal IRCA, that could be problematic if the circumstances were such that the employer took action against the employee because they did not have a matching Social Security number. So in all circumstances, it's best to follow a methodical approach, which understands what exactly does this Social Security mismatch letter mean, how do I address it in a methodical process to rule out any possible errors or other similar problems, and what do I do if the employee, after a reasonable period of time, is still unable to provide the documentation. I've provided some useful web links that you can look at that provide some FAQs as well as some general reference information to address the Social Security mismatch question. And I thank you for listening in today.
Thank you, Peter, for today's topic, the return of the Social Security no match letter, what it means, and how to protect your business. If you have any questions, please contact Peter Guattery at pguattery@wtplaw.com or 410-347-9431. Thank you.